All right, let's jump right in. Today, we're stepping into the courtroom to tackle a fascinating legal puzzle, a real brain teaser that makes you question what evidence even is. We're looking at the case of the silent witness, where what someone does, not what they say, is what ends up on trial.
So, here's the big question that's going to frame our whole discussion. Can a simple action, a gesture, a decision, whatever, be thrown out of court just like some unreliable rumor? I know, it sounds a little out there, right? But this one question cuts right to the heart of what the law even considers a statement.
To really wrap our heads around this, we need to start with the basics. We have to understand the foundational rule that controls what people can and can't repeat in court. You might have heard it called the gossip rule, but in the legal world, it's known as hearsay.
All right, so what exactly is hearsay? Basically, it's any statement that was made outside of court which is now being used in court to prove that the statement itself is true. Think of it this way. A witness can't get on the stand and say, "My buddy Dave told me the getaway car was blue," if the goal is to prove the car was blue. That's a classic no-no. That's hearsay.
But why even have this rule in the first place? What's the point? Well, it's actually super important. It's all about making sure the evidence is reliable. Courts want to avoid basing a verdict on what is basically he said, she said testimony or rumors. They want Dave himself on the stand, under oath, where the lawyers can actually question him. It's all about fairness, right? Getting to what really happened. Okay, so that's the rule for spoken words. Pretty straightforward. But, and this is where it gets really, really cool, what happens when there are no words at all? What if it's an action that's doing all the talking?
So, to deal with this, the law has to draw a line in the sand. It breaks actions down into two big categories. On one side, you've got express assertions. These are actions that are basically a substitute for words. They're meant to be a direct message. But then you have implied assertions. These are way more subtle. They're more like clues. The person isn't trying to say something, but their action reveals what they believe. So the big takeaway here is that some actions are, for all intents and purposes, speech. I mean, think about it. Using sign language to point out an attacker, that's a statement. Pointing at someone in a police lineup, yep, that's a statement too. Even tapping them on the shoulder to identify them. All of these are just non-verbal ways of saying, that's the guy. So naturally, the law says, okay, those count as statements, and the hearsay rule is in play.
And this whole idea, this tension between actions and words, leads us to a classic, almost legendary thought experiment in the law. It's a story that has had lawyers scratching their heads for centuries. It's all about a sea captain and one fateful decision.
Okay, picture this. We're going back to the 19th century. You're in a courtroom and you have a tough job. You need to prove that a ship that unfortunately sank, was actually seaworthy before it left the dock. How on earth would you prove that? Well, this very puzzle was laid out by a famous judge named Baron Park.
And here's the core of his little story. He said, let's think about the ship's captain. This captain, he's a pro. He checks out every single part of the vessel. And after his thorough inspection, what does he do? He puts his entire family, his wife, his kids, on that boat and sets sail with them. And boom, there it is, the million-dollar question. The captain never once said, "Hey everyone, this ship is perfectly safe." Not a word. But his action, right? Putting his own family on board, that speaks volumes. It screams confidence. So here's the puzzle. Is that action, that silent act of trust, legally the same as testimony? Should we treat it like a statement that could be blocked by the hearsay rule?
Man, this one question just lit a fire under the legal world. It sparked this huge debate, a total clash of ideas between two different ways of looking at evidence.
Okay, so let's break down this debate. You've got two camps. In one corner, you have Baron Park's logic. He's all about consistency. His argument is simple. If the captain had said the ship is safe, and we couldn't use that in court because it's hearsay, then why should we be able to use an action that implies the exact same thing? To him, it's an implied statement, period. But then in the other corner, you have the more practical argument. These folks say, hold on a second. Actions are way more trustworthy than words sometimes. I mean, come on. A guy's not gonna lie when his own family's life is on a line. Plus, they worry about this crazy slippery slope. If we start treating every action as a statement, courts will be stuck trying to figure out what someone was thinking when they tied their shoe.
All right, so that's all the high-minded legal theory. It's fascinating stuff, but what happens when the rubber meets the road? How do real courts handle this stuff in actual cases? Let's get into it.
Well, in the real world, courts tend to be a lot more practical. especially with something lawyers call consciousness of guilt. You know, when someone flees the scene of a crime, or lies to the cops, or tries to bribe a witness. All those actions pretty much scream, I think I'm guilty. Now, if you're a purist like Baron Park, you'd say, wait, that's an implied statement of guilt. That's hearsay. But you know what? Courts almost never see it that way. They just let that evidence in, calling it circumstantial evidence, and they don't get bogged down in the whole hearsay debate. It's a practical shortcut.
But get this, the logic can be totally flipped on its head. Check out this other case. It's about bad beer, of all things. So you've got a defendant, and they're trying to prove that the beer they were sold was just awful quality. And their plan is to bring in witnesses to say that they heard other customers complaining about it.
And the judge's reasoning here is just brilliant. It's literally the complete opposite of Baron Parks' logic. He basically said, listen, everyone agrees we could let a witness testify that they saw a customer take a sip of the beer and then immediately spit it out, right? That action is obviously admissible evidence. Then he says, so if the action is okay, why in the world would we block the words, the actual complaint, that communicate the exact same idea? It's a total 180 from the sea captain argument.
So, where does all this leave us today? What's the final verdict? Well, the truth is, it's kind of messy. There's no single clean answer. For the most part, courts today have moved away from Baron Park's super strict theoretical approach. They tend to be way more pragmatic. They look at the action in context instead of just applying a rigid rule that might toss out perfectly good evidence.
And this is the thought I want to leave you with. If an action can be a statement, where do you draw the line? At what point does interpreting evidence turn into, well, basically trying to read someone's mind? It's a huge question, and it really gets to the heart of how incredibly complex the search for truth in a courtroom can really be.